Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. Another point of the transcript that I think sticks out and I think is worth highlighting on the question of Donald Trump's state of mind and his intent is an argument that was had between the prosecution and the defense out of the presence of the jury, and it involved an exhibit that the prosecution was going to introduce an excerpt of an interview of President Trump with Larry King in 1999, where President Trump brags, as you can imagine him doing, as he is wont to do, that no one knows more about campaign finance law than he does. And here is what the prosecution argued. We think that defendant's admission that he has extensive knowledge of campaign finance law is obviously directly relevant to the case. And the defense said, are you serious, essentially? This is a 1999 interview, a thrown-off comment. How can that possibly be proof of Donald Trump's intent in 2016 to commit a campaign finance violation? And the judge sided with the defense on that, said that it looked speculative, that the distance between 1999 and 2016 was pretty large and created a disconnect there. But the reason that I bring this up, Kim, is we are now in the point of the trial where the defense and the prosecution are jockeying over the exact instructions that will be given to the jury. And this is a dispatch from the courtroom from ABC News yesterday afternoon. It says defense attorney Emil Bovee argued that Judge Merchan should tell the jury it must find Trump acted willfully in order to convict. The district attorney's office argued the jury must find Trump acted unlawfully, not necessarily criminally. Judge Merchan said he would reserve his decision about whether to include willful in the jury charge. So, Kim, the details of how the judge specifically instructs the jury, I think, could have a real effect here, because the difference in the minds of these 12 people who have watched this testimony play out about whether Trump acted criminally but not willfully, or whether he acted willfully, that could make the difference to some juror who is still wondering whether this is proved beyond reasonable doubt.
I cannot stress how important this is and how crucial and central the judge's instructions will be in this particular case. And this is different than some other cases. Look, if you're sitting in a jury and it's a murder trial and you're trying to decide if somebody did commit murder or didn't commit murder, in many cases, that's a fairly straightforward thing. As we've just been talking about, this is an incredibly convoluted case in which we don't even have a second crime specified, all kinds of other swirling questions too about who knew what and when, and was it willful? Did you have to have knowledge? Did you have to be the mastermind, etc., and so on? So what the judge now tells the jury about how to absorb and process all of this information that has come at them is going to matter more than anything. I think it was the right call that the judge didn't include this interview because, by the way, just one other aspect, what subject does Donald Trump not say that he's a master of the universe of, even if it's true or not? So I think there's also that aspect of that interview that might not really have been very useful in this trial. But this process is not done yet. They began yesterday. They're continuing, and there's going to be a lot more wrangling. I thought it was notable that the defense attorney was already trying to state for the record his concerns about some of the rulings and the instructions and decisions that have already been made about the judge, which he was open about, saying that the reason he wanted the ability to stand and speak in response to his disagreement to some of those rulings was because he wanted it in the record if there was an appeal.
Monet will give you the last word, but let's make it a reminder to listeners that Donald Trump does not need 12 jurors to acquit necessarily. He needs one juror to say not guilty, which could result, if others think that Trump is guilty of these felonies, in a hung jury. And it is hard to imagine that the district attorney, after failing to prove his case, would try to retry Donald Trump. I suppose it's possible, but in any event, that would not get done certainly before the 2016 election, I think. And so, Monet, Donald Trump only needs one skeptical juror. On the other hand, it might be tough in the pressure of the jury room to be the one holdout when everyone else seems convinced and wants to produce a guilty verdict and get home and close this trial out.
Yeah, I think that there's a reason why jurors are often unanimous in their verdicts one way or another. And it's because when they're talking it all through, there's going to be some of them who have a firm grasp of the facts of the case as they understand them, try to lay it out, and are successful in building a good consensus. And it's very difficult to be the one holdout in any case when it concerns the president of the United States, who is not much loved in New York City. It's even harder. And the case is so convoluted that a persuasive juror could easily be able to make an argument and bring even a skeptical holdout into sway. And so I do think that a unanimous verdict is still the most likely outcome here, despite the prosecution not fully proving its case. But it is entirely possible, because of the weakness of how the case has been laid out, that you could find some person who's willing to stand up and go against ruling in a guilty verdict. And that would be an earth-shattering outcome for Trump and for the country.
Thank you, Monet and Kim. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.